Losing a loved one is one of the most profoundly difficult experiences any family can face. In the midst of that overwhelming grief, the last thing you want to deal with is a confusing legal process.
Yet, soon after saying goodbye, many families are introduced to an intimidating word, probate. If you are feeling lost or overwhelmed by what comes next, you are not alone. Our goal today is to provide you with clear, compassionate, and actionable information to help you navigate the United States probate process. Please remember, this video is for informational purposes only and does not constitute legal advice. When a loved one passes away, the administrative tasks that follow can feel incredibly daunting. At the center of this is a legal term you have likely heard: probate. Simply put, probate is the formal legal process of administering a deceased person's estate. It is the system our courts use to ensure a person's final affairs are wrapped up legally and responsibly. The probate process serves several core functions. First, it legally validates the deceased person's will. Next, it grants authority to identify, inventory, and value all the assets left behind. But before anyone inherits, probate ensures that any outstanding debts and final taxes are paid in full. Only after these financial obligations are met does the process move to its final stage, distributing the remaining assets to the rightful beneficiaries. Probate is not just about paperwork. It provides a structured, supervised environment to resolve any potential disputes among heirs. Ultimately, the probate court's role is to act as an impartial referee, protecting the estate and ensuring that your loved one's final wishes are honored exactly as they intended. But what happens if your loved one passes away without a will? In legal terms, this is known as dying intestate. When this occurs, the state steps in to determine how the estate is divided. State intestacy laws provide a default blueprint for distributing assets. Typically, these laws prioritize the closest surviving family members, passing assets first to a spouse, then to children, and followed by parents or siblings. Since there is no named executor, the probate court will appoint an administrator to manage the process. This person takes on the same responsibilities, ensuring debts are paid and assets reach the rightful heirs according to state law. While every state has its own specific laws, the general probate process follows 6 key stages. Step 1 is filing the petition. This initiates the process with the local probate court in the county where the deceased lived. The executor named in the will, or a close relative if there is no will, submits a formal application to the court, along with the original will and a certified death certificate. The court will then officially appoint the executor or an administrator to manage the estate. Once appointed, the executor moves to Step 2, notifying heirs and creditors. This involves sending legal notifications to all interested parties, including family members and beneficiaries named in the will. The executor must also publish a notice of the probate proceeding in a local newspaper. This serves as a public announcement to alert any unknown creditors that they have a limited window to make a claim against the estate. Step 3 is inventory and appraisal. The executor must identify, locate, and value all assets belonging to the estate. This includes real estate, bank accounts, investment portfolios, and personal belongings like vehicles, art, or jewelry. For complex or high-value items, professional appraisers may need to be hired to determine the fair market value at the time of death. This detailed inventory must then be submitted to the probate court. Moving on to Step 4, paying debts, taxes, and expenses. Before any heirs can receive their inheritance, the estate's financial obligations must be settled. The executor reviews creditor claims to ensure they are valid and uses estate funds to pay legitimate debts, such as medical bills, credit cards, and mortgages. Furthermore, final personal income taxes and any applicable estate taxes must be calculated and paid. During this time, the ongoing expenses of administering the estate, like court fees and attorney costs, are also covered. After all debts and taxes are satisfied, we reach Step 5, distribution of assets. This is the moment when the remaining assets are transferred to the rightful beneficiaries. If there is a valid will, the executor follows its instructions precisely. If there is no will, the assets are distributed according to the state's intestacy laws. This step often involves transferring property titles, distributing funds from bank accounts, and handing over specific bequeathed items.
Finally, step 6 is closing the estate. With all assets distributed, the executor must prepare a final accounting for the probate court. This comprehensive report details every transaction, showing all income received, expenses paid, and assets distributed. Once the court reviews and approves this final accounting, the judge issues an order formally closing the estate and releasing the executor from their duties. One of the most common questions families ask is how long probate takes. The timeline varies wildly. A simple estate might close in 6 to 9 months, but a complex estate with disputed assets or multiple properties can drag on for years. And what about the cost? Probate is rarely cheap. Various expenses will eat into the estate's overall value. These include court filing fees, appraisal costs for real estate, and expensive bond premiums to protect the estate from mismanagement. The largest expenses are usually professional fees. Executors are entitled to compensation for their time. Then there are attorney fees, which might be billed hourly, as a flat rate, or even as a percentage of the estate's gross value, depending on state law. Because timelines and costs fluctuate dramatically based on your local jurisdiction, it is absolutely essential to consult a probate attorney early on to get a realistic estimate for your specific situation. A common question grieving families ask is, what actually has to go through probate? The short answer is, not everything does. It is important to clearly differentiate between probate assets and non-probate assets. Assets that typically must go through the probate process include solely owned real estate, individual bank or investment accounts, personal property, and life insurance policies where the estate itself is named as the beneficiary. Because these assets have no clear designated successor, they require court intervention to legally transfer ownership. But fortunately, many assets can bypass the probate court entirely, saving your family both time and money. These non-probate assets include property jointly owned with rights of survivorship, or accounts with specific beneficiary designations, like life insurance, retirement accounts, and pay-on-death bank accounts. Additionally, any assets properly placed inside a living trust will flow directly to your beneficiaries without court approval. Finally, many states offer simplified procedures, like a small estate affidavit, for estates that fall below a certain value threshold. While probate can be daunting, there are smart strategies to simplify or even avoid the process entirely. The foundation is proactive estate planning. A powerful tool is a living trust. By transferring your assets into a trust, they can bypass the probate process and go directly to your beneficiaries, saving both time and money. Another effective method is joint ownership with right of survivorship. If you own a property with someone else, ownership automatically transfers to them upon your passing, entirely without court involvement. Don't underestimate beneficiary designations. By directly naming beneficiaries on your life insurance policies, retirement accounts, and bank accounts, those funds are distributed immediately. Finally, if the estate is below a certain financial threshold, you may qualify for small estate procedures. This offers a much faster and less formal resolution, bringing peace of mind to your grieving family. Navigating probate while grieving can feel overwhelming, but you do not have to do it alone. A skilled probate attorney provides invaluable assistance during this difficult time. They advise you on your legal rights, guide you step by step through the legal maze, and handle the heavy lifting of preparing and filing complex court documents. If family disputes arise or the estate is complex, an attorney will represent your interests in court, resolve conflicts, and ensure strict compliance with state laws. For complex estates, consulting a professional is highly recommended. Take the next step and visit funeralus.com/directory to find local probate courts today. Thank you for joining us to learn about probate. Understanding this process is a vital step in honoring your loved one's legacy and finding peace of mind. If you found this guide helpful, please like, subscribe, and share your experiences in the comments. Remember, every estate is unique, so always seek professional legal advice. For more resources and guidance, visit us at funeralus.com. We are here to support you every step of the way.